The Environmental Protection Agency on Tuesday updated its regulation that extends federal Clean Water Act protections to wetlands and waterways. The rule, which defines waters of the U.S., or WOTUS, effectively lifts federal protections for wet, boggy areas that aren't connected to a stream, and possibly to streams that don't flow all year long, such as desert washes like you'd see in Phoenix or Albuquerque that only run when it rains. From now on, companies building mines and developers building business parks and highways or nearly anything else that could create water pollution won't have to get a federal permit to pollute. In some states, they may not even need a state permit. EPA issued the rule to comply with the Supreme Court decision that came out in May in Sackett v. EPA. The ruling tossed out earlier definitions of federally protected waters based on the idea that pollution into marshes, bogs, or streams that are only connected to a major river or lake underground can affect the water quality in the larger water body. So the idea went like this. If an isolated marsh, say in Central Park, contributed to pollution to the Hudson River because there was an underground connection to the river, the marsh was federally protected too. That was basically how the EPA had interpreted the Clean Water Act for years, except during the Trump administration. But the Supreme Court wasn't buying it. The justices ruled that only waters that have a direct surface connection to a larger river or lake and are relatively permanent can be protected under the Clean Water Act. EPA's new rule applies those principles to its waters and wetlands regulation, effectively lifting protections for countless waters across the U.S. So if New York City wanted to build a parking lot on top of that isolated marsh in Central Park, they wouldn't have to get a federal permit to do it, and the federal government wouldn't require them to reduce the impact. But the state might. All of the newly unprotected wetlands and streams are protected only by state law, which varies across the country. Some states, such as Virginia, require state permits. Others don't regulate wetlands at all or regulate wetlands no more strictly than the federal government. And in those states, like North Carolina, you can expect a lot of unpermitted development. The environment